Good morning, good afternoon, good evening, wherever you might be in the world. Hello, and welcome back to the 7th Annual International Hit Lab Innovators Summit. It is my distinct pleasure and my honor to welcome our next panelist, our next speaker. They're actually our event sponsors here, Moses and Singer, and I'd like to share with you an exciting new development. Moses and Singer are committed to being officially our first sponsors for the 2021 Hit Lab Innovators Summit. So thank you so much to Linda Malek, Jason Johnson, and Anka, and the entire team at Moses and Singer. Thank you to your commitment to healthcare during this time of the pandemic. It is my great pleasure now to welcome Linda Malek and Jason Johnson. I do want to mention that Jason has been precluded from this call at the moment. He is encountering some unexpected difficulties in joining, but he should be joining us before we wrap up the session. But without further ado, allow me to introduce Linda Malek and Jason Johnson, partners in the healthcare as well as privacy and cybersecurity departments at Moses and Singer, where Linda leads both groups. They'll be talking today about recent legal developments in telehealth. Their discussion will cover issues such as recent federal guidance around telehealth privacy restrictions, transparency, and consent in telehealth, and FDA considerations in the use of AI in telehealth. Please join me in welcoming Linda Malek and Jason Johnson, partners in Moses Singer, our 2020 Summit sponsors, and officially our first sponsors for the 2021 Hit Lab Innovator Summit. Welcome, Linda.
Thank you, Justin, and thank you for that enthusiastic introduction. Hello, everyone. I'm very happy to be here with all of you. And although I cannot see you, I would really like for this to be as interactive a session as possible. So if you have questions, please feel free to put them into the chat so that I can answer them as we go. I'll try to do that as much as possible as we go along. And as Justin mentioned, there are essentially three themes that I'm going to go over today in terms of legal issues and considerations in the context of telehealth, including issues around data privacy and security and changes that have occurred in that context, as well as transparency in the context of telehealth, transparency and consent, and also FDA considerations, as well as certain updates that have occurred. And I see that Jason is joining us. So, and here he is just in time. So he is going to cover the first two topics, privacy and changes that have happened recently with respect to the Department of Health and Human Services Office of Civil Rights, as well as transparency in telehealth. And I'll be covering FDA issues to consider, as well as some new updates. Jason?
Hi, sorry I'm a few minutes late, but I'm happy to be here. So the first topic I'm going to talk about is the loosening of telehealth privacy restrictions, particularly in response to COVID-19. So early on in the COVID pandemic, a nationwide public health emergency was declared. And what that allowed HSS to do is to relax a lot of the restrictions that went into, generally speaking, just medical care. And one area in particular that was opened up and relaxed was telehealth. And as part of that, part of the issue with COVID was getting access to individuals because everything was closed. And so there were some restrictions, particularly related to HIPAA and contact with patients via these telehealth platforms that were potentially problematic because of potential HIPAA violations. And so what OCR did, Office of Civil Rights under the HHS, early on, is that they announced that they were going to give themselves enforcement discretion for HIPAA violations. And so for HIPAA cover providers, if you were interacting with patients via certain telehealth platforms, then even if there was potentially a technical violation, then they would exercise their enforcement discretion as long as you were attempting in good faith to try to comply with HIPAA. And so there was a guidance that was put out early on, which gave some information as to how the enforcement discretion would be implemented by OCR. And the main implementation tool that they looked at was, well, what types of telehealth technology would we allow and which would we not? And so it came down to two types of technology. So what they would call non-public facing technology and public facing technology. And so what does that mean? So this was more in line with, well, who has access to these video platforms that individuals are using? So for example, TikTok. TikTok is a publicly available app. Anyone could log on. There's no necessarily privacy where you and or myself and Linda could TikTok to each other, right? It's all public facing versus something like FaceTime, right? So FaceTime, when you FaceTime someone, you're FaceTiming someone directly, right? So it's not really an open public forum where anyone can log into your FaceTime. And so if the physician was using a non-public facing platform to do the telehealth, then as long as, again, there was sort of a good faith attempt to keep the information private and not disclose it, then OCR would use their enforcement discretion and not enforce technical HIPAA violations. And so they gave some examples of what they consider to be non-public facing communications. So there was FaceTime, Facebook Messenger, Google Hangouts, WhatsApp, and Skype. And for the not for the public facing, things like TikTok, which I mentioned, Facebook Live, Twitch, and Slack as well. And so as long as you were using one of those non-public facing technologies, then OCR would not enforce the HIPAA violations. Interestingly, the other side of this was, generally speaking, if you're a HIPAA covered entity and you use a third party like that, you're supposed to have a business associate agreement in place with your business associates. And for a lot of these apps like FaceTime and such, physicians weren't necessarily going to be able to get a business associate agreement in place with these entities. And so even if that was the case, again, OCR would not require and would exercise their enforcement discretion if you didn't end up having a business associate agreement in place with some of these providers, as long as you weren't attempting to use the information in a bad faith way. And what is bad faith? So again, OCR gave a few examples. Nothing that's criminal, right? You weren't using the data that you collected or had access to for any other purpose. Would there be a sale of the information, the health information, or using it for other marketing purposes? And then, as long as you're using the non-public facing app, then you should be good. Now, interestingly, these provisions are only in effect, and the enforcement discretion is only in effect as long as the public emergency has been declared. However, last week, HHS put out a list of questions and asked everyone to weigh in on which of these COVID-related rule relaxations would you like to keep in place. And when you look at the request for information that was sent out, there's probably 35 pages of different regulations and guidances that have come out from HHS across sort of the spectrum, where they're asking, what should we keep, what should we get rid of? They set the time frame only for 30 days, so all the comments should be in by the end of December. But obviously, this administration is going to be leaving at the end of January, so it kind of remains to be seen whether or not all of these regulations and guidances that came out during this administration will continue post January 20th, as well as how much longer the national emergency will be declared. Those are unknowns at this point, but it's possible that some of these rules will continue. There is a big push to allow telehealth services and remote technology to continue to be used by physicians, because I think a lot of physicians and a lot of patients have found a lot of value in this. And so we'll see if this continues, but at least for the time being, there is a little bit of a discretion there if you're looking to get into the telehealth area. Now, turn to the next topic, which is the disclosure, transparency, and informed consent in telehealth, which is what I want to mention. So even though there is enforcement discretion, you still have to act in good faith. And if you're looking long-term to maintain a presence in telehealth, then you not only have to worry about federal laws, but you also have to worry about state laws, and you also have to worry about the Federal Trade Commission. And so part of the part of the issues that you have to look at is whenever you're using your vendors, vendor vetting is a very important aspect of any type of business and the business relationships. Because there is a huge boom in telehealth services right now, there are a lot of small time and big time players that are getting into this area. And so it's really important that you know and understand who you're working with. And so vendor vetting becomes even more important in this area, because there are a lot of privacy related issues that could come up, particularly with smart homes and smart apps on watches. There's a lot of information that people are collecting. And that information is being used in a whole host of purposes, AI related software to develop. And so yeah, I think the big issue that comes up with this is making sure that you know who you're working with, and then you have a good set of requirements in place to ask basic questions about who your vendors are, right? So again, what type of systems are they using? Are they using cloud-based services that are well known to folks, or are they using their own internal servers, right? What policies, procedures do they have in place for data breaches and to protect the data? Are they trying to be HIPAA compliant? Do they have any type of particular system or organization that they're trying to follow when they're trying to protect the data? And so, vendor vetting doing this upfront will hopefully save you a lot of headaches on the back end. In addition, you need to make sure that you have informed people properly as to the type of information that you're going to collect and how you're going to use it. As I mentioned, this isn't just a HIPAA issue. This becomes a state privacy law issue. Most states have their own privacy laws that deal with the collection of personal information. And those vary from very broad pronouncements to very strict pronouncements. And so wherever you're collecting data from, you need to make sure that you understand whether or not you're subject to particular state laws and particular disclosures to individuals under those state laws. In some cases, you may be required to get consent from individuals in certain states to be able to use the data that you're collecting for purposes other than just the provision of services. In addition, the Federal Trade Commission has, in recent years, been very active in the area of privacy notices and disclosures. And so they have used their power under Section 5 of the FTC Act, so for unfair and deceptive trade practices, to come after individual companies related to failure to properly disclose what data was either being collected or how that data was going to be used. And we've also seen this at the state level. In New York, in particular, which has some of the more strict privacy general rules in the country, the Attorney General in recent years have come after multiple mobile health apps, for failing to accurately describe their collection and use policies and the privacy policy that was provided to the individuals. And so there are, again, significant specific requirements as part of the privacy notice that you have to have under New York law, and those privacy policies didn't have it. And so, it's very important, again, to understand where you're operating, who you're collecting information from, and then make sure that you are, adequately describing what your uses are. If you want to use it for other purposes, again, it's just, you just have to be, honest and upfront about it. I think that's the lesson out of all this, right? You shouldn't try to hide anything. I think people are more aware than they used to be about how much information is being collected on them. And so as long as you're being truthful and honest up front in the privacy notice, it should hopefully help you avoid a lot of the issues and potential headaches on the back end. And I think I'll turn it over to Linda at this point.
Thanks, Jason. One other thing that I want to emphasize in terms of what Jason's talking about with respect to your privacy notices is that, of course, there are a lot of off-the-shelf privacy notices, and the thought is nobody reads the privacy notices, so they look pretty boilerplate. But in matter of fact, what we have seen is that a lot of enforcement authorities, including the FTC, as well as state attorneys general, have been really scrutinizing those privacy policies. And that's really what they point to in terms of levying fines and penalties against various types of technology companies, because in their view, those privacy policies are essentially, as Jason said, your sort of communication to the user in terms of how you're actually utilizing the data that you collect about them. And so it is actually really important to draft those privacy policies with some thought as to what is actually happening. And transparency really is key here in terms of communicating to the user what your intentions are with respect to the data. So something to really keep in mind as a practical matter. Turning to FDA issues now, there's been a real uptick in the use of AI in the context of telehealth. And so you see AI, for example, in technology that is used to assist the physician in their own diagnosis of a particular issue. For example, in technology that's used to measure wound healing over time, or imaging that is being used remotely, and machine learning tools are incorporated into that technology in order to assist the physician. And the FDA has indicated that this kind of software often can be considered software as a medical device, and so has to be regulated by the FDA. And so, moving a little bit beyond privacy issues here, this is a particular regulatory regime that you need to be aware of. And in the 21st Century Cures Act, which was issued in 2016, there was guidance that was laid out there in terms of what kinds of software would be considered a medical device and what sorts of exceptions there would be. And then in April of last year, the FDA issued a discussion paper sort of delving deeper into this in terms of criteria that it looks at in determining whether or not software is considered to be a medical device and should be submitted to the FDA for approval or not. And without going into a lot of detail around it, some of the high-level guidance indicates that, for example, things like a wearable device or software that is governed by a mainframe server, those types of criteria in the use of the device lend it to being viewed as a medical device. But if it's a wellness application, for example, and is not being used to diagnose a particular disease, that typically doesn't fall into the category of software as a medical device. It's an exception. Additionally, if the software and algorithms are transparent to the physician such that the software is not being relied upon exclusively by the physician, but rather the physician's really exercising their own judgment in terms of how to incorporate that software into their treatment, that's a criteria that arguably pulls it out of the medical device criteria and medical device classification. But it's a tough line. It's the sort of thing where you really want to get some expert advice in analyzing this, because increasingly, as AI becomes more and more intelligent, it becomes more and more difficult to really make it transparent, such that the physician's not really relying on it for the treatment that they're giving. So FDA is currently reviewing all of this, is trying to keep up with the evolution of the technology, and it's just something to really keep in mind. In terms of updates in this area, as Jason mentioned, HHS recently issued a request for information and comments with respect to which of its guidance should remain after the pandemic is over. That includes the OCR guidance that has been given with respect to loosening of restrictions in telehealth. But one thing to note there is that at least in informal conversations that we've had with OCR, what they've indicated is that the loosening of these restrictions is not a free-for-all. You still have to be cognizant of certain rules like using the minimum information necessary, putting in place adequate protections, and really acting in good faith. So that's really important to keep in mind too, even as HHS is soliciting comments. The other thing that I think is really important to note is that CMS has really expanded the number of services in the telehealth context that it's going to reimburse. And that's, I think, really good news for the industry, because as CMS goes, so does the private sector. And so because of this expansion that CMS just announced with respect to services that it will cover in the telehealth context, I think we're likely to see private insurers covering this too. So CMS is doing this for Medicare, but I think that private insurers will follow. And then lastly, in the enforcement context, one thing that's been really interesting is that even though we've seen this loosening of restrictions, we've also seen a real uptick in enforcement by the federal government, by the U.S. Attorney's Office. And just very recently, there was the biggest healthcare enforcement action ever, where the U.S. Attorney's Office came down against a national network of providers for what they claim to be about $6 billion in fraudulent claims, about $4 billion of which they attributed to fraudulent telehealth services. And there, what they were looking at was also criminal activity where the telehealth services were either not being provided, or there was little to no interaction between a medical professional and an individual. But again, I think the takeaway there is that even though there have been loosening of restrictions, there's still a requirement to act in good faith and to follow the guidelines that we've laid out for you here, at least at a high level, because there is still enforcement activity. So with that, I encourage any questions. And Jason, is there anything that you think that we should also cover? And Justin, I know you've joined. Just want to make sure that we answer any questions that have been posed.
If I may, I'd love to chime in with one of our audience questions, Linda. And I think this is going to be actually directed to Jason Johnson. This is coming from our audience actually in Ireland. Rory had a question about GDPR. With the introduction of GDPR in the EU in 2018, given that the regulation has extraterritorial scope, how has the introduction of GDPR affected the management of data by US telehealth companies in the USA, if at all?
Yeah, interestingly enough, I just helped a client with the same exact question, right? So, what happens if I have data in the U.S. that I'm sending over to the EU? What are my obligations? And so, at least when the data is coming from the U.S. to the EU, the only thing you have to worry about is what obligations you have in the U.S. So whether that's state or federal, right? And so. Data coming from the EU to the US is obviously a bit of a different challenge. And so even more challenging given the recent Shrimps 2 invalidation of the Privacy Shield and the general desire to say that because the US government can access any person's data, we don't think there's any secure way to send information over to the US. And so I think if you're sending data from the EU to the US, you obviously have to comply with and think about GDPR And then there is the sensitive personal information that comes under GDPR and the direct consent requirements. And then your data transfer mechanism. There was recent guidance that was issued, and so based on that guidance, it appears that working toward an encryption method to transfer the data from the EU to the US would work. But just as a basic matter, if you're a US entity working in the US, then US law is all you have to worry about at that point.
Excellent. Thank you. Thank you so much, Jason. I just have one more question. We have time for just one more question. I think this one's going to be directed towards Linda. Our audience wants to know, are there any other issues that you want to think about or really be on the lookout in telehealth going forward?
Sure. So I think that it's really important to kind of view your telehealth implementation in an enterprise-wide way. And that includes what kinds of third parties, for example, are you using as vendors to supplement what you're doing? And vetting those vendors is really important. We haven't talked about that in too much detail, but there too, there's been a lot of enforcement activity, and it can create exposure for you if you're the primary entity. So really doing some due diligence on any vendors that you utilize to help support your platform is a really important thing to think about in the context of telehealth. And also, I think just going back to the question that Jason just answered, where is the information coming from? Where are the individuals? Because if you're talking about that from a US perspective, then you've got to think about state laws and engaging in best practices across the country, if that's what you're intending to do, is provide a platform across the country.